Welcome back. I'm top music attorney Miss Krystle, and as you know, we have been covering the Johnny Depp Amber Heard trial. Now, the court is on break this week. The court had to go to a conference, a judges conference, but we didn't want to leave you hanging. We had some testimony from Amber Heard. Now, she is not by any means done. She has a direct examination to continue with when we get back next week, as well as cross examination. We have a lot to unpack. Now, I've been watching your guys' comments and seeing your opinion as we kind of went through Johnny Depp's case in chief. As you guys know, this is a defamation case. We have claims by Johnny Depp of defamation. We have claims by Amber Heard of defamation. But honestly, what this is wrapped up in is really a family law case. We're talking about DV and a whole lot of problems. So I'm kind of lucky today that I have a special guest. Now, I'm going to be bringing in my very longtime good friend, Timothy M. Collier. Tim is not only a civil litigator, but he is a trial attorney. He's been with me on trials that I have done. He's been a mentor to me, and he's been following this case pretty closely. So we've had some pretty interesting conversations. And so I want to bring him in. So we're going to be unpacking Amber's testimony, what was believable, where are there some potential problems, and where do we think that this is going to go based on the evidence that we've heard thus far. So without further ado, let's jump into it. Hi guys, I'm top music attorney Miss Krystle. I'm an entertainment attorney, public speaker, and creator of the Top Music Attorney School for artists and record labels. I'm the owner of Dukes Up Records, and most importantly, I'm an independent artist. Don't forget to subscribe and turn on those bell notifications so you don't miss my weekly videos giving you my best tips on the music business, industry news updates, and teaching you how to stay legally protected. Let's go. All right, so we're going to be getting into some legal procedure. Now, I have this broadcasting right now across many platforms. We are live on YouTube, on LinkedIn, on Facebook. We are everywhere. So as we're live on all these platforms, you have the ability to ask questions, leave your comments, and everything is being fed into my station right here. So we will be having you in the conversation with us. So let me go ahead and bring in Timothy Collier right now. Here we go. Hello, Tim.
Hello. Thanks for having me.
Yeah, thank you for being here. So yeah, like I was saying, guys, Tim and I have been friends for a long time. And so we get to kind of, have our cerebral discussions about cases that are happening. And obviously on this channel, we cover all of the juicy cases and what's going on in pop culture and pop news. And because, Tim is not only a civil litigator, but he deals with a lot of not only, trials that we're seeing right now, but procedural issues. And so there have been a lot of questions about things like hearsay. We've heard that objection quite a bit. And so, I thought from a starting point, let's start with day 14. Okay, so the last 2 days where we finally heard some testimony from Amber Heard, starting on day 14, and then we'll go into day 15, which will take us up to where we're at right now before the court took a break. So the first thing that I kind of wanted to jump into was we heard testimony from Donna Hughes, who was the expert witness on behalf of Amber's team. Now, as a quick reminder to everyone, we've gone through Johnny Depp's case. Okay, so because he's the original plaintiff, he gets to bring his case first, which means, well, actually, Tim, let's ask you, what does that mean if a plaintiff gets to bring their case first?
Yeah, well, it's almost kind of like an unfair advantage, if you will, especially when you have claims where you have a plaintiff who's bringing claims and then you have someone who's bringing counterclaims. But we saw Johnny Depp and his team, and I think even Johnny Depp was on the stand for a week straight, but we've seen that team basically in front of this jury for a period of a couple of weeks and, using my word, indoctrinating the jury of their story. So for weeks on end, they're hearing this one-sided biased story by Johnny Depp and his team and those experts and whatnot. And then the first thing that Amber Heard's team needs to do is essentially, attack that indoctrination, try to get the jury over to their side. And what we're seeing right now with their very first witness, which was a strategy change in the last couple of days.
Yes, it was.
Is to get this expert witness in. And it's the first time we've seen so far, at least, the battle of the experts, because we saw Johnny Depp's expert who did that evaluation of Miss Heard, and basically said nothing to see here as far as any sort of mental diagnosis. But then you have her expert coming in and seeing. So it's a credibility. It's a battle of the witnesses. So pretty interesting.
Yeah, so we're getting into kind of a discussion as it relates to your expert witnesses. And for Johnny Depp's team, their expert got up and she's a forensic psychologist. And so she got up and said, look, I did this extensive evaluation of Amber Heard based on my actual interactions with her. And I think it was something like 14 hours that she was interviewing Amber Heard, and then she came up with a extensive report. And that report is given to the jury, and the jury is going to look at it and examine it and consider it as part of, their final weighing of the facts and evidence. And so we got to hear basically, this expert come up and say, I think Amber Heard is borderline personality disorder, and that she has, for example, some narcissistic qualities, some tendencies to manipulate, some tendencies to kind of take control of these situations if they're not going the way that she wants. So not painting Amber Heard in a very good light.
Not at all.
We're not surprised by that, right? And then, as far as the cross-examination, the attorney was simply just trying to attack and say, well, aren't you biased? Don't you, aren't you a fan of Johnny Depp? And isn't that what you do to try to attack the credibility? If you can't really hit the facts because you're not an expert, what can you do as an attorney?
Yeah, well, this is a little interesting. Actually, I found both experts to be pretty good witnesses, but typically you don't say stuff like that, right? You attack the actual science, you attack the actual report. I mean, really, in my cases, do I have somebody like a Johnny Depp where I can say, well, you like him, you like his movies, you like his acting, because that's usually not the case in normal cases, if you will. And so what you do is you look at the reports, you look for the inconsistencies. Usually you have Johnny Depp's team certainly knew of Amber Heard's expert that was going to testify. That's all been disclosed prior to trial. So there's reports there that she's going to look at and try to poke holes in that in her reporting, try to draw the sting, if you will. And that's what the team will try to do, and what Depp's team did try to do. But yeah, normally it's just attacking the report, attacking the science, looking at the methods and use that she used, and deciding whether or not that's right or wrong. So, and I think they did get into some of that as well too. But I thought that was interesting in just saying, well, hey man, you like Johnny Depp, of course you're going to be biased.
Yeah, and I don't know how persuasive it was, because they tried getting into it and kind of like a gotcha. Isn't it true that, you went over to Johnny's house and had dinners and drinks with him? And then,
Right.
The expert just responded and said, the attorneys had me at Johnny Depp's house being interviewed for, basically this job, and they served dinner. But then, okay, so let's compare now Amber Heard's expert, Donna Hughes, who basically got up and said, Amber has PTSD. And so from my observations, she has suffered, some kind of abuse. As far as in the same kind of way to kind of attack her credibility, we then heard Johnny Depp's attorney kind of going at things like, why didn't you complete forms, right? So kind of haphazardly completing things that you knew were going to be used in trial. Or, to the extent that you're talking about PTSD, there seemed to be kind of this generalized reference of, what caused it, and not being able to really point to specific instances of what triggered the PTSD. So I think that, ultimately I felt that both experts were believable. I felt that they came off credible. And then at the end of the day, it's the world of the jury and what they're going to do with that information.
Yeah, right. Or do they just cancel each other out, right? So they look elsewhere.
That's a good point. All right. So then we're still on day 14. So we finished up the cross-examination of Miss Hughes, and now we're getting into Amber Heard's direct testimony. Okay. So remember on how this works procedurally, Amber Heard's going to have an opportunity to tell her story. And that's what we heard from Johnny. Johnny had an opportunity to come up for several days and to tell his story and to, not really be interrupted too often by his attorney. And so they're really open-ended questions. But what was different was that while we got to hear more of Johnny's backstory, hearing about his abuse and upbringing and why he got into acting, we kind of got straight into it with Amber. And so Amber, for me, seemed to be very reliable, or believable, I should say, in the beginning. I felt like she was being very authentic and she was coming off very pleasant, and she seemed to be, really directing her energies towards the jury. And, something that Tim and I were talking about was in preparation of your witnesses, you do have to tell them, here are good things to try to do, here are good things to say or not to say. And so in that same kind of vein, we've heard a lot of objections and saying, for example, hearsay. So let's hit on that really fast. So Tim, tell us about hearsay. How do we get hearsay objections and what is it?
Sure. Well, hearsay is a statement made by a declarant outside of the court, not under oath, and usually not by a party. And it's just a statement said by somebody. It could be written, it could be verbal. And generally speaking, it's not allowable in court to prove the truth of something. I always kind of equate it to the telephone game when we were kids, right? The rules of evidence are set up to try to get the best truth that we possibly can through the court proceeding, especially in front of a jury. And the rules aren't perfect by any means, but if you think about it, when you tell a story to someone and then they tell the story and then they tell the story, sometimes the beginning of that story ends up very different at the end. And that's what hearsay is trying to preclude. And so they want firsthand knowledge or firsthand statements, and what your understanding was based on a bunch of circumstances, not just what somebody said. Now, hearsay is unusual because there's something like 28, maybe 23 exceptions or exemptions to it, depending on where you're at. And one of those can be a statement that a party makes, for example, or it could be as simple as an excited utterance by someone not of a party. If somebody says, "Oh my God, he just hit that car," usually that's some sort of excitement. And that statement, although hearsay, out of court, not sworn, can be used because it was an honest impression or reaction to some incident. So there are a lot of exceptions like that.
Yeah. So as kind of a baseline rule then for, as we're listening through, it's, for example, we hear Amber Heard starting to talk about when she was having a discussion with one of Johnny Depp's children, right? She was talking to his daughter. Now she started to explain what the daughter said to her that would draw an objection.
Sure, absolutely. Yeah.
Yeah.
Yeah. Because essentially you have somebody recounting or recanting or something somebody else said. What you're supposed to do is have that person come on and testify, so that person could give you their firsthand knowledge. Now, obviously, they're not going to put Johnny Depp's daughter on the stand, but that's generally how you would overcome a hearsay, or a simple way to at least overcome a hearsay objection is put that person on the stand and let them testify to their personal knowledge.
Something that I was kind of thinking as I was watching Amber Heard's testimony was that she continued to say, she was trying to protect Johnny Depp's daughter as related to, Johnny Depp was using, drugs and he was drinking. And so she was really concerned about the daughter and just how much she wanted to protect this little girl. And I just remember thinking, kind of putting the little girl on blast, worldwide as you continue to talk about her. I don't know how you weigh, that kind of thing if you are trying to protect someone and yet you're putting them on kind of a national and international pedestal by talking about them during trial. And so, that's just a side thought that I had. But let's talk a little bit about just, as far as the court of public opinion, I would definitely say that things are pretty heavily weighted towards Johnny's side as of now, from what I've seen. And people are finding that Amber's testimony is not very believable. But let's talk about the actual, I guess, mannerisms and what she's doing. So something that I noticed when I was watching the testimony was that she did have a tendency when she was telling maybe an emotional story to kind of gear her body language towards the jury. And I just remember thinking, at least for me or for anyone that I know, if you're having an emotional moment, it's a very vulnerable thing. And you have a tendency to maybe kind of clam up, to turn inwards, to maybe be a little shy or embarrassed because you're being exposed in that moment. And I felt that conversely, Amber seemed to kind of, gear her body and, her gestures towards the jury, and then to also look at the jury. And so, back to, do you think that that is in just her preparation, perhaps? And that maybe her attorney said you want to make sure that you were trying to connect with the jury? Or is this just her putting on some kind of big show?
Well, the answer to that is it could be all of it, right? I mean, attorneys do coach their witnesses and the atmosphere of sitting in the witness stand, where the jury's going to be, how to talk to the jury and not to the attorney when they're asking questions. And it's all very unnatural, right? We as attorneys can't coach answers, but we can, prepare them for the atmosphere. So even though I may be asking the questions and the witness is answering, it's not a conversation between the witness and I. We want the witness to turn to the jury and try to connect with them. And all of that going on with the judge sitting right next to you, and the person you're suing probably less than 10 feet away from you, creates such an unusual dynamic. Now, with all that said, mostly emotion, at least in my experience, regardless of who's on the stand, emotion doesn't stop just because there's a pause in the questioning or whatever. And so, that probably comes across in the jury. The other thing we have to consider too is we're sitting here watching this on a live stream or TV or something. It might come across differently sitting in that room and having it more visceral. So that could be it too. But one thing that I'll say, which relates to the hearsay that we're just talking about, is Depp's team has picked the strategy to object politely, really, and appropriately, almost all the time. And what that does is it breaks the flow. It breaks the flow of the question and the answer that we saw on Depp's team when Johnny Depp was on the stand. Amber Heard really hasn't obtained that flow yet. And that could come across as awkward or diminish, the look of credibility. And that's strategic. And that's why you see a lot of these objections.
Yeah, so guys, we especially heard that on day 15, right? We're still in direct examination of Amber Heard, but Miss Vasquez, the one of the main lead female attorneys on Johnny's side, you started to hear pretty quickly that she would object very frequently to Amber Heard's statements. But she did this she did this in a very almost perfect way in my mind, because she was very gentle with her tone, with her emphasis. And so it didn't come off as demeaning or rude or aggressive. And I think that's really important, right? Because if you are interrupting someone who's giving an emotional, empowered kind of speech or storytelling, you don't want to come off that you're trying to prevent the jury from hearing that story, right? But you need to still interrupt the flow. So to your point, you were saying it can be helpful, right? Because now we're helping to not only interrupt that emotional flow and connection with the jury, but you're helping to almost stop the story, right? Because we also felt that Amber Heard was almost getting off track at points. And that was one of the objections that we heard.
Yeah, absolutely. And obviously you pick the strategy before you go in. Are you going to let the story be told because you want to have more to cross in the cross-examination? Or are you going to object to break the flow? And obviously the Depp team has decided to do what they've done. And I think it's been mostly effective. And it has just broken all of that flow. The other thing too is that, if you're in the midst of a trial and you're drawing a lot of objections on hearsay, there's a way to reform your questions. And I see this as a real failure in the Heard's legal team. You can ask those questions in a way in which will not draw an objection. And you hear sometimes the attorneys say, well, I'll just rephrase, because they know that's an appropriate objection. And then you just kind of circle around, create a little more foundation, get to what your understanding was, instead of asking them what was said or what have you. So I don't see them coming back around to establish that portion of the story. They just kind of move on. And I just curious why they do that.
So Cody says they only have to believe a shred of Heard's testimony for it all to go her way. So, Tim and I were talking about this, right? So what are the claims? Going back to Johnny Depp is claiming that the op-ed piece that Amber Heard did in 2018 was defamatory towards him, even though it didn't name him, right? In the actual article, people knew who it was. And when she said, I'm an abuse victim or survivor. And so he's bringing his defamation claims based on that. Amber Heard is countersuing for defamation. So what do you think? If they believe a shred of Heard's testimony that she was abused, well, it just takes one incident, right?
Yeah, Cody's right on. I mean, the truth is the ultimate defense to any defamatory statement, right? And so she can prove that she believed it to be true, right? It's not that it's the absolute truth. It's just that she believed it to be true. Then, that takes the day. That's her defense to Johnny Depp's claim. Doesn't necessarily mean she wins on her claims, but she at least defends appropriately and probably successfully to Johnny Depp's claim. And there seems to be this extra standard, at least that's pled in this case, where there is a reckless disregard for the truth. Now, that is a part of all defamation claims, but that seems to be a higher standard than in some states. Here in Arizona, we have that standard, but it's a heightened standard. One other thought I had too, which was interesting, is that whenever you kind of put in somebody's profession at risk. There's defamation per se, which means
Right, and that's
damages.
what I was going to say.
Yeah.
Right.
Now, the statement itself doesn't have anything to do with Mr. Depp's career, right? She doesn't say, well, he stole a bunch of money from this person, or he didn't show up. Well, I guess they are kind of saying that, but the statement.
Well, now she's saying that.
Yeah, the statement itself in the post doesn't say that, so that's probably why that claim wasn't pled.
Yeah. So, Stokely Miller, what do you think based on character statements from friends and exes of Johnny and Amber? So, from the witnesses that we've heard, of course, these were all part of Johnny's case in chief, and they were very favorable to Johnny, talking about, and in a very consistent way, I will say, talking about the fact that Johnny is a very kind of, happy-go-lucky, laid-back kind of guy. It's really hard to kind of get him flared up, and even when you do, he has a tendency to go to another room. He walks away from the fight. But testimony that we did hear from the therapist, the couples therapist for Amber and Johnny, was that, Amber seemed to really know how to trigger and get under Johnny's skin. And so it seemed to be kind of, Amber's a special case. And I don't know how good that is for either side, just to essentially have the therapist saying that they were toxic and mutually abusive.
Yeah, that takes the day, I think, in both cases. So both parties walk away with nothing. There just has to be one incident. We have a lot of incidents here, and none of them are whether you're on listening to Johnny Depp or Miss Heard, none of them are actually denying the instances actually occurred. They just have different, perceptions of what happened. And some of them are very far apart, but, nobody's saying that never happened. And then, of course, you have the corroborating evidence, which is the video and the text messages and some of the recordings in which you can kind of hear some of this stuff taking place. Now, the jury has to decide whether or not that's abuse, at least as Amber Heard said it in that article. And if they decide that that is abuse, as Amber Heard believed it and put in that article, then that'll carry the day for her as far as the defense against the defamation claim brought by Johnny Depp.
So, as part of Amber's case, she's citing to 14 incidents of domestic abuse. And where she kind of started with her story on their relationship was how we met. And they said, she said they met on the production for the Rum Diaries movie. And she went into this elaborate story about just falling madly in love with him. But she preceded that with kind of this what I found to be a little bit odd and almost tantamount to a Me Too movement kind of experience that she had with Johnny. And so what she testified to was that on the production, I guess she had gone into, his room and she was wearing a stage robe and she had some kind of, bottle of alcohol for him. And he had lifted the back of her robe with his foot and then kind of using his body had moved her onto the bed and said something to the effect of yum. And her description of that wasn't, oh, he was kind of flirting with me, but it came off as a kind of creepy Me Too moment. And so what stood out to me about that was just that she then went on to say, then she started dating him. And then she fell madly in love with him. And not that one cannot proceed or follow another in, anyone's life, but it stood out to me is that the kind of person that you would want to date if you were kind of creeped out by them?
Yeah, I mean, what you're getting to is the essences of credibility of the story. Why would somebody, even start a relationship with somebody that did that to or acted in that inappropriate way? And so it begins, and maybe unfairly, I don't know, but to question whether or not that incident happened as Ms. Heard testified to, if she was going to go on and fall madly in love and such as she further testified. It's kind of a disconnect, right? And so the jury has to kind of try to connect that, or again, maybe they just say, well, I don't need that story. Sometimes juries do weird things and they can latch onto one story and say, this is true. I believe Ms. Heard's testimony in this one incident. And that's all they need in order to say, well, I don't need to make a decision on the rest of her credibility. It could go as simple as that. But yeah, I think you're right on. I mean, the credibility on the way she kind of talks about things. Another example that I think is, she really chastises Johnny's Depp's alcohol and drug abuse. But yet you have a story here where she brings a bottle of alcohol when they first meet. And then there's testimony, at least from the Depp side, that she did a lot of drugs and kind of was the party girl as well. And so in one hand, she's saying, I didn't approve of this. And then in the other hand, she's partaking. So it's kind of hard to jive all of those statements together. It almost becomes confusing.
Now, as far as the composition of the jury, my understanding is that there's actually only 2 females on the jury. And then, of course, there are alternatives. So whether those 2 jurors will even finally, have participation in that final vote, we don't know. So let's just take, for example, if the final determination is made by a group of men and we have these instances of, it's kind of creeped out and it's this kind of Me Too moment or thing that she experienced, I'm wondering if it plays a little bit differently because it's a man. And I wonder if a man maybe feels like this heightened sense of, I certainly don't want to, have an abuser get away with it, so to speak. And I don't want to not believe. Or if it was all women, would it be different? And I don't know the answer to that. In your experience, would that impact whether you selected a man or a woman in this particular case to be one of your jurors?
Oh, my experience, juries are amazingly unpredictable. There is no answer. They're all individuals. So for everything that you just said, I could probably say, well, there are men that are going to be more compassionate to the woman because they want to hold Johnny Depp more accountable for whatever reason, past experiences, biases that are all natural in every juror. As far as the women, they might just say, well, they might hold Amber Heard to a higher standard and say, well, you don't go to somebody's dressing room and bring a bottle of alcohol dressed in a robe, just to, introduce yourself. Maybe she was looking for more and women shouldn't do those types of things. I'm just spouting. I don't know, but everybody's an individual. And every time I've tried to predict a jury, it hasn't gone well in the outcome. I'm not a betting man, that's but
right.
you do in the beginning try to, select a demographic that you believe is going to be favorable for your client. And whether that's just gender-based or professional-based or experiences based, when, you go through all that through a process called voir dire, where you get to ask the jury questions, you try to get the most favorable jury. And then you're right. There's probably a couple alternates on this jury because the trial is so long, I think 6 weeks in total. And who's out, right? Is it both women? Is it 2 men? We just don't know until the end. And in fact, we as viewers won't know until probably the report after when a jury comes out, if a juror comes out to talk to the media or whatever, because they'll say juror number whatever and juror number whatever, you're excused. And so they've just sit a 6-week trial in front of Johnny Depp and Amber Heard, and they don't get to deliberate. They go home.
No, and actually, it's 7 as of now. They're planning on 7 weeks of trial, and so explain to our viewers really fast. So the 2 alternates, what is that? What is that for?
So basically, I mean, especially in a 6-week, there's alternates in all trials, jury trials, but in a 6-week trial, you definitely want to have a couple at least. There's not always 2. Sometimes there could be more during COVID. Sometimes they would do more. But basically, what it is if somebody on the jury that you've just impaneled gets sick, or God forbid something happens to them where they can't serve anymore, those alternates will then come in and be part of the jury. Now, they don't know they're alternates during this process of the trial. That's decided later. But if you lose less than the required number of jurors, then you have to start the whole trial all over again. So they basically build 2 extra in, at least in this case. So that way, if something happens to any one of the jurors, or even 2 of the jurors over the 6 or 7 week period, as you just said, then they don't have to start the process all over again.
Yep. So Chris asks, recounting events from several years ago, little things can get forgotten or a little twisted. Okay, so very good point. And in fact, this was something else that I was thinking while Amber was testifying. So she would be very detailed in certain things. For example, when she got into the initial instances of abuse, she talked about in 2013, she was having a conversation with Johnny, and then the wino tattoo came up. Okay, so referring to Winona Ryder and Johnny's relationship with her and the fact that he had a tattoo. And I guess Amber did not like this and it escalated. And then Amber says that, Johnny smacked her, which caused her to fall to the floor. And so she recounted about the dirty carpet and her face being in the dirty carpet. So, not just in that one instance, but other instances of abuse, she talked about specifics, right? We're talking about colors and smells and things that she saw. But then when asked, for example, what was her participation in those events or what had happened in leading up to it, she would kind of have these gaps in her memory. So, of course, Chris, I would agree with you and say, of course, things that long ago, it's been so many years at this point, but it's odd to me that she is remembering very specific details, but then having very large gaps on things that do involve her. So what's your take on that?
Yeah, well, this should be handled by an expert because there are thousands of studies out there probably that whenever somebody goes through some sort of traumatic event, they generally will remember the details of that event, for a good period of time and a long period of time, and sometimes forever, depending on what time of traumatic event they've incurred. So that may not be unusual, but you need that to be explained to help the credibility of the witness. And I don't think that's been done so far. So an expert might come on and say, whenever we go through these experiences, we develop these triggering events. And so the smell of the carpet is remembered, or the color of the carpet, or what, I ate that day, or whatever the example may be. But yet that same person can't remember, a date or put something in the context of time if it was 3, 4, 5 years ago. And so they should have somebody to explain that, to account for that. And they haven't yet. So if they haven't, they should. And Chris is right. I mean, there are probably 1,000 more studies that the more time has passed, the lessen your memory, the less you remember, but also the more your memory is shaped because you've had conversations with people that either were there or not there, but whatever, your perception changes based on those conversations. And so that's why you'll see depositions or from previous where you impeach them, and you'll hear a very common question with the attorneys, and you'll say, well, it's 2 years now, but at that deposition it was only 2 months after. So wouldn't it be correct that your testimony back then was more correct than it is today? We hear that a lot because of the lessened passage of time.
Well, and we're going to get a little bit more into other evidence that has now been submitted or not submitted into this case, but this was an interesting question I wanted to bring on, or a statement. So Hamish Harris says, and it appears she snorted something in court, if you saw that clip. So we, as the general public, have the opportunity to be on social media. And I have seen a lot of people going in on Amber Heard, specifically from her testimony, kind of gotcha, aha moments. Like, for example, I did see this clip where it appears that as she is kind of blowing her nose, that there's something white that is there for a moment. Now, of course, that could be a million things, but if people are jumping to conclusions. I saw another clip today where it seems that maybe she poses for a moment for a picture as she's kind of, clearing her nostril. And so going to the whole, being very opportunistic. Is that a crime? Does that showcase that, she's not being truthful? And, Tim, you brought up this point earlier. She fired her PR team right before taking the stand. So how does that come off?
Well, first of all, the jury knows none of this, right? And the jury should not be seeing these clips. They should not be researching it. They might have a total different impression of what happened with the Kleenex, or what we believe, she snorted something. I find it personally hard to believe that she did that on a witness stand in the middle of court, but it was odd, to say to least. But the jury's not going to see any of these memes. They're not going to see any of these clips. They're precluded from doing so. And if they're found out of doing so, they actually get kicked off the jury. So really what we're talking about is
that we saw that from a witness on Johnny's case, that someone admitted to watching clips, and that witness was immediately excused and their testimony was stricken.
Right. Yeah. And the court will admonish the jury every single day, every single break, not to talk about the case until it's been handed to them, and not to watch any news or social media, which is tough. That's 7 weeks. Think about that. 7 weeks of no social media for Miss Krystle. I mean, that the world, but yeah, it's we look at those things and we analyze those things. We don't even know, quite honestly, if who in the jury actually picked up on it, if they picked up on it, because we can capture those things, but they're not in there watching the testimony. They're not allowed to do that as well either. So
yeah, so we get to, again, the general public, we get to have in the court of public opinion this continuing narrative and, kind of building the case for Johnny. And that does seem to be what's happening, but we have not heard Amber Heard's entire case just yet. So another instance that Amber Heard testified to of abuse is that she was talking about being backhanded, after being accused by Johnny Depp of having multiple affairs. And that seemed to be kind of this common theme. Now, having your guy kind of accuse you or this or that, is that the weirdest thing in the world? No, but then obviously she goes the next step. So as part of those accusations that there would be a physical component and that he actually backhanded her. and he was wearing his rings, which, you know, I don't think there's been a day that's gone by in trial that Johnny Depp's not showed up in full gear with his, you know, trademarks kind of rings on both hands. And so she said, he backhanded me with the rings, and I remember my teeth cutting into my lips and that there was blood on the wall. And so we're talking about, you know, a pretty violent moment. And so when it comes to kind of this evidence and the pictures, I feel where we're having a little bit of a weakness from Amber Heard's case is that the images aren't quite reflecting what she's talking about. These really quite graphic kind of things that we would expect to see with having a broken nose, for example. She testified to having blackened eyes. And we have certainly seen pictures of bruises. You know, I don't think we've seen anything that quite matches what she's describing yet.
Yeah, I agree. And of course, again, we're talking about the credibility. Is the jury believing it? Now, one thing we have to remember is that we're still in the direct examination of Amber Heard. And so lawyers will employ a strategy in which they'll come out of the gate with something that's memorable for the jury to latch onto. And then you get through all the stuff you got to get through. And then you end with something that they'll never forget. At least that's what you're trying to do, right? And we haven't gotten there yet. We don't know what that piece is going to be. And it's either going to give the jury and quite frankly, the public opinion, right, what we've been waiting for her to give us, right, to corroborate everything that she's saying, or it's just going to fall flat. And you know, if I had to predict now, although I said I wasn't a gambling man earlier, it just seems like it's going to fall flat for the very reasons you're discussing. I mean, some things just don't seem to jive. You know, you would expect to see some pretty horrific pictures of a broken nose, or when she describes getting beaten in the face multiple times, those types of things. And we're just not seeing that yet, at least.
So another instance that we heard testimony on was, I guess Amber and Johnny were taking a flight, and they did MDMA with, you know, not each other, but they got the flight attendant to also do this drug with them, right? So they're all getting high together, and the flight attendant is being a little touchy-feely with Amber. And so we hear, not just in this instance, but also a separate instance where some female who's involved, they're all doing drugs together, and they start to become physical in some kind of way with Amber, putting a hand on a shoulder, hand on a knee, and that Johnny becomes very violent. And that, you know, he threatens to break their wrist, or he smacks their hand away, or he grabs their wrists. And so we've heard a couple of, these similar stories. But as I understand it, for at least one of the instances, there's not going to be anyone to actually corroborate these statements, right? She's not actually going to have whoever this person was come up and testify, which I find a little odd. Is it because maybe the person doesn't exist? Why would that be?
Yeah, again, credibility. And you would think that an incident like that, I mean, you're on an airplane. So even if it was just Miss Heard, Mr. Depp, the flight attendant, you're going to have a pilot there at least, and you're going to have maybe a co-pilot. I'm not sure who else was on the plane. But there's going to be somebody that comes forward and say, yeah, this occurred, right? And we haven't seen that yet. Now, again, we're in the very beginning stages of Amber Heard's case in chief. Maybe we get somebody, we just don't know. I have personally not looked at a witness list to know whether or not we have somebody upcoming to help corroborate that, but we just don't know yet. But they're going to need somebody because that one is a pretty extravagant story to just leave there without any other evidence.
Yeah, and you and I were talking about this other instance where Johnny Depp and Amber Heard were traveling by plane. They were going from Boston to LA. And we were just kind of discussing how Amber had testified that Johnny was drunk and high, and he was saying kind of belligerent things at her because she had had a love scene with James Franco the day before. And so he was incredibly jealous and in a jealous rage. And so he was just saying kind of very venomous things about, was he doing this to you? I want to do that to you. And then becoming physical. So he was starting to throw things at Amber, and even getting to a point where he slapped her a few times. And then finally it escalating to where she alleges that he kicked her violently in the back, which caused her to fall to the ground. Now, the difference with this story was that now we have a number of witnesses who were in the plane who witnessed this, who we've heard testify already. Okay. So for me, it's tough because at this point, we have heard the complete opposite from these witnesses who said, we have never seen Johnny abuse Amber. And in fact, you know, we've seen Amber drinking. We've seen Amber, you know, poking Johnny and being violent with Johnny. And so because we've heard different stories, at least as of now, it's almost, well, if you're going to believe Amber, you have to just simply disregard everything else you heard from all the other witnesses.
Yeah, and I thought that's the story you were talking about in the first place. My apologies. But yeah, I mean, you have to get somebody to come on and corroborate that. And it just hasn't happened yet. In fact, as you just stated, there's been corroboration to nothing has happened. And if I'm sitting on that jury, I have to wonder about the story just on its face, only because, in one moment, apparently Mr. Depp was very aggressive and active, and to the point where he was abusing and hitting Miss Heard, but yet almost second later, at least how I took the testimony, seconds later, he's almost passed out, comatose and inaudible, but mumbling words. And I suppose, again, that could happen. It just doesn't jive with me. But again, this comes down to your expert, right? You get somebody on there that talks about somebody's patterns and behaviors in severe alcohol or drug abuse. If they put on somebody like that, it could explain that kind of behavior and put those two things together and say, yeah, that's very common. You could be heightened in 1 second and then very almost passed out in the next second. If somebody will come on and explain that, then we get some corroboration.
Yeah, and we did hear audio as well during that line of questioning. And so Amber had pulled out her phone at some point after that had occurred. And so she was recording Johnny. And so you can hear Johnny just kind of moaning, making sounds, sort of trying to speak. So, excuse me. So, from the instance of, we believe that he was drunk, we believe that he was high, but did he do what she is saying happened?
Right. Yeah. And, I guess we'll wait till the end to make a decision on that one. But I'll go back to what I said before. Although there seems to be a lot of incidents here, the jury really, I think, in my opinion, only has to pick up on one in which Johnny was the aggressor and decide whether or not that constitutes abuse enough to qualify the statement as truth. I mean, that's really all this case is about.
Yeah. I'm getting a little water from our show producer, that Orko. He says choking on camera is not great. Okay, so then let's talk a little bit about the prenup. All right, so we heard Johnny Depp testifying about the prenup and the fact that his sister and one of his friends had been recommending get a prenup before you get married to Amber Heard. Obviously, at this stage, Johnny Depp is the successful actor who is well established. He is, by all accounts, financially lucrative, and Amber isn't yet. Okay, so it was recommended to him to get a prenup. That caused a huge fight. We heard testimony from him about that. They did get married. And then there was a second touch on this. His sister once again said, Johnny, go and get a postnup. You should still get something signed. And this caused another eruption, another fight. So we did hear testimony from Amber on this topic. And what we heard Amber testifying to is that she was the one that wanted the prenup. And that the fight was essentially caused because Johnny was like, oh, because you think that our relationship is going to end so soon. And that, how can you not believe in us? And so for me, again, going from is that believable? And I had a little bit of a hard time with that. That, the less established person would be the one saying, I wanted to have a prenup in any fashion. Because typically that's something that's very difficult for any couple to talk about. It's a very difficult bridge. No one's usually going to be very happy about it. But
Right.
often it's going to be the person that has more assets, more value. So what's your take on that?
Yeah, I mean, I'll give you the lawyer answer. It depends. I mean, not all postnump or prenumps specifically preclude the less having asset spouse. I don't know how to say that, but at any rate, the person in a lesser position, it doesn't necessarily preclude them from anything and everything. It could set some spousal maintenance. It could set a limit of award or whatever. And at that point in time, that limit might have been more than Ms. Heard has seen in her lifetime. So in that regard, maybe she did want the prenup because it was guaranteed money. Whereas if it was a total preclusion to any asset Mr. Depp ever had, then that would, like you say, be hard to believe that she was actually advocating for that. This all comes down to is what questions does the lawyer want to ask? Is that really relevant? I mean, how does that get to the truth of the statement of Ms. Heard in the Washington Post? You run the risk of what you're saying. That comes off weird. Why would she want it? You put questions in the juror's mind. I, as a litigator, may have not even gone there. I think that's probably a pit that just doesn't need to be explored.
Yeah, and Chris says, I can't believe Johnny would be like that about protecting himself from a possible event. That's what we heard Johnny talk about. Johnny said it wasn't his idea. He was just getting pressured from his sister, who we heard her testify already, and she is his personal manager, right? So that's the kind of thing that usually the people around you who want to see you protected will make that kind of suggestion, and that he begrudgingly had the conversation. Now, we do know that they never had a prenup, they never got a postnup, and so when it came time for them to actually divorce as part of that divorce settlement agreement, Amber Heard was paid $7 million. And, we haven't quite gotten into that portion with her direct examination, but I'm very interested to see what happens on the cross. So Ms. Vasquez is slated to do that cross examination. And so I think if, her objections is any tell of kind of what we can expect, I'm looking forward to her cross examination and hopefully seeing a fluid, answering or asking questions that I have, because there are many.
Yeah, absolutely. I agree. The cross examination is going to be interesting indeed, because obviously it's going to go to her credibility in the truth. How you handle a cross examination is going to be key, especially with a possible victim here, and that's clearly behind, at least in part, the choice to have a female do the cross of another female possible victim. We saw the
And why
cross.
is that?
Well, it just comes across more compassionate.
Right.
I, as a male attorney, have to be at least cognizant, um, especially when I was doing family law, of a mother on the stand who was alleging domestic violence. You have to be soft, you have to be compassionate, and you should be anyways. I mean, I'm not saying you shouldn't be, but um, it is common to make that decision when you have a team of lawyers in that particular situation, to have somebody where the jury might feel is more empathetic to the witness. And so, it's strategy, and it's also true for the most part. Now, that might be a stereotype, might be a generalization, but that's just sometimes what we have to deal with when we're trying to predict the minds of the juries. But it will be interesting, and it will be interesting how she handles it and the types of questions. She also has probably a larger range of ability to go a little harder on Miss Heard than maybe a male would. And so she might take advantage of that opportunity. We saw the male attorney cross-examine Johnny Depp. I personally thought at times that was not an effective cross-examination, but at times it was. I think they left some questions out that maybe they could have really kind of hammered down, but I kind of feel like it's going to be the same style with Miss Heard. Hopefully a little slower, because I think sometimes attorneys pick up the pace too much to try to get the point, and that stuff just gets missed by the jury. They need to slow down.
I felt that dynamic when Amber Heard's male attorney was doing that cross for Johnny Depp, and that Johnny Depp was being very slow and methodical and pace with his pacing, and yet you had this attorney that was trying to kind of drive the questions in. And so obviously not that that's ever going to kind of meet in tandem and flow. I just felt like it was a little rough.
Yeah,
And so
and I
maybe
think
to your point.
Yeah, and I think Mr. Depp won the day in that cross-examination. Although I think the cross-examination set up their closing, what they needed to do. That all come back around in the argument. But I think, at least as far as the perception and winning favor over the jury, I think Mr. Depp, although there were some tough things for him to deal with, I think in the end he probably did better than most in gaining favor with the jury, even through a cross-examination. Personal
Well, and
opinion.
going back to kind of my comment about Amber Heard's body language, right? So as she was telling her stories or getting emotional or crying and almost seeing to try to get that affirmation from the jury to see if they were kind of buying into it. I didn't get that so much from Johnny. Now you might have your, qualms with Johnny. Was he boring to tears? Was he very slow paced? I've seen all kinds of comments about that. But I did feel that when he was reflecting on memories, it seemed very genuine. It seemed like he was going and internalizing and looking down. And so, to in that comparison, I did find Johnny Depp's recounting of stories a little more believable as actual memories.
Yeah, and we have an unfair advantage, or he has an unfair advantage, because most people know Johnny Depp and his mannerisms before the trial, right? So we know that that's how he's going to be, and having that baseline reference of what he is, through other interviews or whatever, because of his, just his public image, we have something to compare with. Whereas with Miss Heard, we don't have it as much, at least, and so we don't have that baseline with Miss Heard. So is she normally like this? If she is, then she's incredibly credible. If she isn't, she's not credible. But we just don't have that baseline. I think that's an unfair advantage that most people don't think about.
Well, and I mentioned this to you earlier, but I saw another clip on social media and someone had dug into a movie that Amber Heard had done. And so in the movie, in this particular clip, she was recounting, being attacked by someone and she was crying. And it was very, very similar to, what we're seeing on the stand for her. And of course, the point just being, her acting hasn't really improved. But I think to your point of, having kind of a baseline of is this how they normally act? Right. Now, we kind of go back. Oh, let me answer this. Joel, when I choked, is that water or vodka? It's 5 o'clock somewhere, but it's just water. Calm down.
Too bad.
Cody, Johnny's not a blackout drunk, a drunk self-admittedly, but there's a big difference. They're only a professional would be able to rebut. So yeah, there's no question. I think that Johnny and his team did a good job to take ownership of the fact that Johnny likes to drink. Johnny has done drugs. And so by not attempting to be this saint, I think was good. I think it's very important to take ownership of whatever bad facts exist in the case. And they said this in the opening. These are things that he's done, but he did not do the things that Amber said. These are two different issues. And I think that as we even saw that footage of Johnny becoming very upset, he seemed to be drinking, seemed to be maybe a little bit drunk. And so he's slamming cabinets, and then he becomes even more upset when he finds out that Amber was filming him without his knowledge. Again, does that show that he is then an abuser?
Yeah, I think it does. That's just my personal opinion. And I think even if it doesn't, it's enough to at least say that Amber Heard believed it to be true for the purpose of that statement. So I think that's probably enough to get there. But yeah, I say this often, but I as an attorney have to make a decision on what it is that is going to happen in the case. What is going to be presented against me? And here, you have years of run up to this trial. He already lost a case in the UK. You have to make disclosures before trial before a certain time. So the audio and the video and the documents and the text message, all that is disclosed. And, at some point you decide, well, am I going to take this thing to trial or am I not going to take this thing to trial? And at some point they made the decision, despite all of this bad stuff, I guess, or these incidents or these text messages and everything else, I'm going to go ahead and go to trial. I have a hard time believing that I would, if I was sitting in Johnny Depp's counsel's shoes saying, I think you got a chance to win this. I mean, as soon as I start looking at these text messages and stuff, I said, I can make the argument if I'm on the other side that she believed it to be true just from this one statement or this one video. So do you really want to go and air out your entire laundry of this relationship in front of the public over something you're probably going to lose? I just would have had that heart to heart. Now, maybe Johnny Depp said, yeah, let's do it. Let's go. Let's roll. But I find the irony to be that he's actually saying that her one statement in the Post has impugned his reputation, and he lost Pirate 6 specifically, maybe other jobs. But yet he took this to trial, and he's really kind of impugning his own reputation by seeing a behind the scenes look of where he is and what he does in, at least that stage in his life. I guess you can't ignore the irony there of what's going on. But
yeah, and seeing Johnny Depp as a human, right? And seeing, in some very unfavorable light, pictures and videos and to the text messages, right? So in his redirect, right? So when his attorney had the opportunity to come up and, provide some clarification on certain things that had come up during cross-examination, he got into the text messages. Let's provide some context of when you said these pretty terrible things about bodies in trunks and things you wanted to do to Amber. What was the context of that? And he would talk about, well, I was texting a buddy. And yes, I said it in that way, but it was meant to be kind of tongue in cheek. It was meant to be very extreme. Of course, I would never do that. So, do you find that when you are litigating and your redirect opportunity is context really important when you have bad facts, like, maybe some pretty aggressive or awful text messages?
Well, yeah, absolutely. And in fact, you try to get them precluded, right? There's a process in which you go through in order to get certain evidence precluded based on one thing. It could be as simple as the prejudicial value outweighs the probative value, which means that this statement is so bad, it doesn't really go towards the case because he was talking to a friend and it's clearly dark humor, that kind of thing. And I'm curious to what the pretrial procedures were and what they did try to preclude, because there seems to be a lot of stuff getting in here that I don't know that should have. I still haven't really seen the big connection that alcohol and drug abuse means relationship abuse. Nobody's really put that connection together for me in the case. Maybe I just missed it. I can't watch every minute of it, but so to that end, why is all of that in this case? Does it really does Johnny Depp's alcohol and drug addiction have anything to do with the truth or the veracity of the statement in the Washington Post? And my answer to that is no, I don't think it does. Maybe a little bit of that comes in, but not to the degree it has. So what kind of lawyering took place before trial that allowed all that stuff to get in? Because I think this trial was lost before day one of impaneling the jury.
Well, and as far as the exhibits we've been talking about, they're like, I need exhibit 527. So just the volume of exhibits, and they're redacting stuff on the fly, right? So they're like, please redact this. We're only using this page or this portion of the audio. So it does seem that maybe not all exhibit issues were dealt with ahead of trial. I don't know the answer to that, but an interesting point for sure. So Joel had a question about prenups. Are prenuptial agreements made public once the parties are in court? Well, as part of our exhibits, if they, for example, don't have some kind of confidentiality, which they probably do, but there's a lot of stuff that is confidential, like, for example, therapist notes, right? That falls under HIPAA. That has all kinds of protection, even at the federal level. And it's up to the parties whether that's going to come in. And so for me, we're hearing a lot of, from the medical providers, the physicians, the therapists. So in this case, Johnny and Amber both said, yeah, we want it all out there.
Yeah, sometimes that stuff can be filed under seal too. So it is part of the record, but it's not visible to the public. So it's only in the courtroom that you can see that kind of stuff. So, there are ways to handle that as well. I've had it both ways where the parties are like, well, it's just a prenup that doesn't list any of our assets or anything. So yeah, and you're required to actually file those or give notice of a prenup or a postnup in a family law case. In a defamation case, probably not. But, if the parties agree to it, by all means, it's in there.
Now, you and I didn't have a chance to talk about this, I don't think. So something that kind of went viral a couple weekends ago was that in Amber Heard's opening statement, her attorney had held up this compact, right, and said, this is the compact that Amber had to use for the duration of her relationship with Johnny because she would get beat and she would have bruises at different stages. And so she had to use this compact with different colors to cover the bruises. And so what happened is that this company that makes this compact put out a video and said, we didn't even make this compact until after their relationship was over. So this thing goes super viral. And of course, we're expecting that this might come up on the cross-examination for Amber because, of course, her attorney stood up and said, this is the compact that she used. And the company has now come out and said it wasn't even in existence. So if you are Amber Heard's attorney, how do you deal with this?
Oh, shit is how you deal with it. Every once in a while, you're handed a gift in trial, and Johnny Depp's team probably are going to take that gift and open it to the fullest extent. If you're lying about this, their attorneys can't even get it right. Does that get them there? I don't know. Probably not. But it certainly is a big mistake made by attorneys, and attorneys are required to do a reasonable investigation outside of what their client tells them. So there's a lot of things that go on. First of all, you're holding up what may or may not be something that's already been admitted into evidence in an argument, right? That has to be cleared by both sides. There could be an objection to that particular piece of evidence. I'm assuming that if it was held up and it was not made part of evidence or wasn't admitted into evidence in Johnny Depp's case, which would be unusual, then the parties agreed that she could use that in the argument. At least that's the way it would be in Arizona. We have to consult. So I would imagine that Johnny Depp's team didn't even know that that compact was not made until after the allegations. And so even though they agreed for her to use that, now all of a sudden they're handed this massive gift of like, look, this wasn't even true or whatnot. So if you're the other side, you just say, well, what I meant to say, or you can kind of loosely say, well, it was a compact similar to this, or what I meant to say was this, or yeah, you're right, this wasn't made after, but the previous model was almost identical to this. I mean, there's ways to handle that, but you're right, that bell is rung. But the jury, again, won't see those reports in what the company put out unless somehow that gets admitted into evidence as well. But certainly the Depp's attorneys are going to attack that.
Yeah, I would be shocked if they don't. And I do think there are ways to claw it back to say, oh, no, I didn't mean this exact brand, even though those were the words that she used. I didn't mean the exact brand because there are a lot of companies that make compacts like this to help cover discoloration and things like that. But it definitely weakens the overall credibility for me. So my question then would be, at what point could Amber just throw her attorney under the bus? So if she gets pressured on this question to say, I told my attorney actually it was this, she got it wrong.
She should absolutely do that if it's the truth, right? She should absolutely say that, it was something simpler. She must have misspoke. She should absolutely do that.
All right, so I didn't pull this back when we were touching on it. So Cody was asking what we're going to find out is Johnny was willing to pay $7 million to get out. Well, he did pay that to get out of the divorce or through the settlement. And so one of the issues is Amber had committed to giving those amounts to charity and she didn't. And so we heard a lot of testimony from that organization. She had made, several $100,000 of donations. She got Johnny Depp to donate. She got Elon Musk to donate. He did $500,000, all great, but she did stop. Now, they were very nice, and I think that there may have been a little bias here, but they were very nice about it she just came on hard times. She couldn't make these payments any longer for whatever the reasons were. But the bottom line just being, Amber had made these statements of what she was going to do to make these donations, ultimately to benefit victims of domestic abuse. And she didn't. So as far as her being very concerned about her public image, I'm wondering how she's going to deal with that.
Well, in the case or in the public image, that's her new PR firm's job. But in the case, it's going to be tough if that comes out because it's just another area in which she said something that was at the very least incorrect, right? Was it misleading? Was it purposefully misleading? The jury will decide that. But it's just another piece of the arsenal for the Depp team to show that she's saying things that aren't true that we know not to be true. So she's doing that here. She's doing that here in this case, and she did it in that op-ed piece in the Post.
Joel asked, will Amber get an attitude when she's being cross-examined by another woman? So when we heard the cross-examination of Johnny Depp, I had just pointed out a few times he started to get a little sassy and he started to push back a little bit. And that's not necessarily the best look. You want to try to be as neutral and just to answer the question. But what do you think? Is this attorney going to rile up Amber Heard? Is it going to be a bloodbath?
I hope so, man. I'm looking forward to a great cross-examination. You like a little drama in your cross-examination. But if we go by the way she's objecting, she doesn't seem that confrontational. And you have to decide as an attorney in which way to approach a particular witness. If you can build some rapport, sometimes you can elicit some better answers and some truthful answers because that person almost begins to trust you, even on the witness stand, although they're adverse. Whereas if you challenge them, sometimes you're met with just pushback and you're not getting what you need out of that witness or that cross-examination. And we might see a little bit of both because sometimes you have to feel the witness out and what's going to work. Is it going to be some stern or is it going to be some compassion? You kind of experiment, especially in what will be a long cross-examination, to see which is most effective.
Well, I'm also curious with Amber's temperament and pacing of her answers because she, at different points, she seemed to increase in pacing, increase in emotion. And so I think that if this attorney can maybe, get her, we could see her potentially stumbling if, she has a problem with something or saying something she didn't mean, versus with Johnny Depp's cross-examination, again, he was always very slow in his pacing. So he would take an extra breath. And I even noted he had this mannerism that he did before answering. He would go, and he would do something before answering the question, which I think is a good strategy because it gives you a second to think. And so I think that maybe if you are feeling intimidated or you are feeling like you are being attacked, there might be a tendency to try to answer or to be combative. So this could be a fiery cross-examination.
It could be. It could be. It'll be fun to watch, regardless of what it is. I think this particular lawyer that's doing the cross-examination is one of the better lawyers on both teams. So
I agree.
yeah. So I think it'll be good to watch and fun to watch.
So on that point, from your perspective, what are your thoughts on Amber's lawyers? Like them not letting Johnny answer their own questions. So we were just speaking about Miss Vasquez, who is the, I keep saying she's kind of the main female point attorney. We've heard a number of attorneys on Johnny's side. He has multiple law firms, I think. But we've heard quite a few female attorneys, but she's the one that did the opening statement, and she's the one that will be handling the cross-examination for Amber Heard. My opinion is that every time I have heard her speak, she's very concise. She seems to be organized. She seems to be well-tempered. So from what you've seen, let's start with that attorney. What are your thoughts?
Yeah, I agree. I think she's on. I've seen some really weird things, quite honestly, from both sides. Just picking one example from the Depp side, one of the younger male attorneys, and I don't know his name, but he started objecting to a piece of evidence that was already in evidence, and he's making foundation objections, which are admissibility objections of even getting a piece of evidence in. Once it's in evidence, you can show it to anybody. You've already crossed the hurdle. It's in the case. And so he was objecting to that and the judge even said it's already in evidence. And so, he sat down. I alluded earlier to some of the questioning that I believe by Ms. Heard's team, which could be easily overcome without objection, especially the hearsay objections. And I thought that they did a very poor job of circling back around and getting that information in a very common objection. Hearsay objections are incredibly common. And to get around those it's just asking the question a different way. And every attorney should know how to do that,
right.
Especially.
Well, which we heard, right? Especially with, even on the direct examination for Amber Heard. We heard her attorney trying to start asking a question. It would draw an objection. So she would try rephrasing it. It would draw an objection.
Well, she was rephrasing wrong. Yeah, that's what I'm getting at is that's not the way to rephrase that. The other thing is she's telling her witness, you can't say what they said. And that's an instruction from a judge. It's happened enough that I thought about this the other day, that if I'm on Depp's squad, I probably would have said, Your Honor, we're getting really close to coaching the witness here, and telling her how to testify. If Your Honor wants to admonish the witness and say, you can't talk about what other people told you or said, that's fine. But just as an example, when she gets into that, instead of asking it that way, just, for example, you were in the house with the bodyguard for a period, or the bodyguards were in the house for a period of time while you were outside. Correct. And this was on the certain day. Correct. And they did their investigation and they talked to several people inside the house. Correct. Yes. And they witnessed some of the damage. We heard that on testimony. Correct. Yes. And when they came back out, what was your understanding of where they were at in the house, or what they looked at, or what they investigated? Right. And she can go in and she can answer that. But this attorney is asking not what her understanding was based on all those foundational questions. It's almost like she's saying, what did the bodyguards tell you when they came out? It's almost equivalent to that. So it's very easy to get around that, but they're not. And I find that to be a little bit unbelievable in the magnitude of this team that should be in this case.
Well, I've said this on a previous live stream. I just go, I wonder if for maybe some or all of these attorneys, if they don't typically litigate. Maybe these were just the attorneys for these parties, and then they are now being thrown onto a national and international platform for a litigation case, and so they are trying to sharpen their chops in real time, but they're not necessarily the top litigators. But I will say one of my impressions that I had, and I believe her name is Miss Brittenhoff, and so the attorney with the very short hair on Amber Heard's side. We heard her as part of the opening statement team giving I would say a little bit more of an aggressive kind of presentation with the storytelling. And for me, it was a tiny bit off putting because she seemed to be ad libbing, right? So she had some notes, but she really wasn't referring to them at any point. Versus the other attorneys seemed to be very organized and concise with the points that they were making. She was just kind of off the cuff, but we've heard that as she's now gotten up to do either direct or cross examination. She's drawing a lot of objections. I think that could be avoided. And, she seems to be kind of relying on handwritten notes. Everyone's style is different. But for example, when you have your preparation, are you tending to kind of just work off the cuff?
Well, sometimes, yeah. I mean, you get into a line of questioning where you've prepared maybe even an outline or whatever, but especially in a cross-examination, it's really tough to predict what the answers are going to be. And so it's not so much the attorney having the preparedness in a script, in a sense, because you're going to have to deviate that almost always. But you have to develop the art and the practice of how to ask those questions. And that's what I'm not seeing. And kind of to your point, I mean, if I have 4 or 5 attorneys on my team, you better be damn sure if I'm in a trial court, one of them or 2 of them are going to be civil litigators, because that's just, you lost before you walked in the door, because of all the procedure and the objections and how to work a courtroom and whatnot. So, so to answer your question, yeah, I mean, you try to prepare as much as you can, but really it's the art of knowing how to ask questions, whether you're on a script or you're kind of digressing into something else, because that's just where the line of questioning went.
Yeah. So Joel had a question. Are there any police records on domestic violence that prove that Johnny has abused her? From what we've heard thus far, and we heard from 3 different officers, and we watched body cam footage, and we looked at what they had reported, because some of them didn't even take reports, right? So they testified that they on call went to the apartment that Amber Heard and Johnny Depp were living. She appeared to be fine. She didn't want to make a statement. They didn't see any bruises or marks, and so this had been an instance where Amber had later then alleged that Johnny had hit her in the face. And so, for purposes of Johnny's case, that was pretty good. And that we had the police officers themselves saying we didn't even take reports because we didn't see anything. And we didn't believe that there had been any kind of physical abuse. So that's what we know as of now.
All right. Yeah, the most boring part of that testimony becomes the most important, right? Is the officer's training. You go through that biography. Where were you trained? What did you do? That kind of stuff. But when you go through that, they're trained to look for that stuff on those types of calls, because they're not going to believe anything that's coming out of anybody's mouth, because it's always he said, she said. So they're going to look for physical signs of injury and that kind of thing. They're trained to do that.
So Christine says, if Amber was truly a victim, she wouldn't risk her life in provoking an abuser by recording them. I've seen this a couple of times, and actually taking it a step further on, direct examination, we're hearing that Amber actually gave a knife to Johnny at one point in their relationship. And my question to that is, that's kind of an unusual gift to give. And so if you're in a relationship with someone who has been abusing you for the majority of your relationship, to not only give them an actual weapon, but I believe that the, engraving on it was until death. I think it was in Italian or something, so that seemed a little bit unusual at best. But as far as, recording, I don't know. I don't know the answer to that, as far as, would someone be so scared that they would never even attempt to do that? But something else that has come up is, any of these times that Johnny was allegedly knocked out drunk, and these gaps of time that Amber had to kind of escape, why didn't she? And we hear all kinds of different reasons why people stay with abusers, but what do you think about that?
Yeah, well, I mean, obviously it's all odd, but you're also dealing with, Johnny Depp is kind of an odd guy, right? I mean, that in one sense is almost the perfect gift for him. It's incredibly romantic under normal circumstances and that kind of thing, if you don't have all this stuff that's going on. And when that gift was given, I don't recall. It could have been when they were madly in love or not. I'm not sure, to be honest with you. I forget the actual testimony. But it is not uncommon, believe it or not. I mean, I deal with this quite a bit. We deal with orders of protections. We deal with family law cases in the past, even through some civil litigation, defamation cases. It is not unusual for the abusee, if you will, the person being abused, to stay in the relationship. It's not unusual for that person to buy gifts that would not normally make sense. It's not unusual for them to video or even sometimes antagonize at points. I don't know why. I don't know the science of that. That gets into the experts, but I can just tell you that that's more common than you would think.
So Joel had a question. Can Johnny sue the movie company if he wins the case against Amber to get Pirate 6 back? What's the answer to that?
Yeah, I don't think so. You can't. I don't think so. It would be a monetary damage. But I'm sure, well, first of all, we've heard there's no contract here. So there's no breach of contract. I mean, it was a handshake deal. Maybe it was a verbal agreement.
Right. Or could he have had maybe an option? We don't know. We don't know the answer to that. So if you do,
Okay,
5, you have
yeah.
an option to do 6.
Yeah, good point. I mean, I'll give you the answer I give everybody. Anybody can sue anybody for everything or in anything. But if Johnny Depp was to sue Disney to get into Pirate 6, Disney would probably settle it out. It'd be worth Disney just to pay whatever they were going to pay him and then go on and either just kill the production or put somebody else in it. They're gonna stay more than arm's length away with that, and they got plenty of money to say, all right, fine, here's your salary, go away.
Well, and the other piece here is who has been named in this case and who hasn't. So as it relates to Amber Heard's case against Johnny Depp, because she's countersuing him for defamation, she didn't name the attorney. So the very simple basis of her claim is that Johnny Depp's attorney, outside of court and the protection and immunity that court gives you when you say bad stuff about someone to try to win your case, outside of court, Johnny Depp's attorney said some bad stuff about Amber. That's the basis of her defamation claim. So my question that I was having was, why didn't she name the attorney as well? Why is it only Johnny Depp?
Well, the only thing I can think of, and I haven't read the pleadings, but it would be under the theory of agency. So whenever you have an agent who takes an action or says something on behalf of the principal, and the principal here is Johnny Depp and the agent would be the attorney, then those comments or those actions can be attributed to the principal, which in this case, again, would be Johnny Depp. There's so many questions to that for me as a litigator. Number one, was there an immunity that attached to the attorney, right? Even though it was outside of court, was it within his capacity of the attorney? Was he advocating for his client? Even though it was outside the court, can he make those comments under, an absolute or qualified immunity? Maybe that was motioned at some point in some motion practice and it wasn't. I don't know the case of that, but the only theory I think that could keep that claim alive is under a theory of agency.
Okay, right. And so the theory of agency, just very broadly, being that if you have a hired gun, an agent who is speaking or doing things on your behalf, you can be potentially liable for those actions, or in this instance, those statements.
Yeah, and we commonly see that in the employee-employer relationship, which is really kind of similar to, you're employing an attorney essentially, but the employer is responsible for the acts of the employee in most cases. Same thing, kind of, but different in the sense that it's an agent-principal relationship.
So Victoria's asking, can they still gather evidence, or is everything in evidence already?
You can't gather evidence, but it's not in evidence already either. But the process is that by a certain time, the parties have to have disclosed everything they have or they want to present at trial. If it's not disclosed by that time, absent good cause and lack of prejudice, they can, they have a continuing duty to disclose. But if it's not disclosed well before trial, you cannot use it at trial. So you can't gather more evidence while you're there at trial. But it doesn't.
Now, what about I'm sorry to interrupt you. I was just going to say, what about something like impeachment? What about a cosmetic palette?
Well, a piece of evidence, I can challenge that statement. I can go to Ms. Heard. Well, isn't it true that, whatever the company was, didn't make that particular compact until whatever. And then she's going to have to answer that question. That's not a piece of evidence. That's evidence. That's just a question. So I can ask it, sure. If I learn new things in the course of a trial, I can certainly ask that for impeachment purposes. But being in evidence is something different. Essentially, as you were stating earlier, there's, I think, 700 documents or whatever. All that is marked as an exhibit, but it's not in evidence until it passes the evidentiary hurdle. And that means the court has to say this particular exhibit is admitted into evidence. And sometimes that's not objected to, and sometimes it is. But not all exhibits that are marked make it into evidence.
Yeah, guys. So as we're watching the trial, you'll hear the attorneys, and sometimes before they even start their next line of questioning, they'll say, Your Honor, I'm going to pull out exhibit 203, and we're going to use this certain audio portion. And then they sometimes will deal with objections. And so it might draw an objection. I don't want this in because of this, or you need to make sure that something's redacted. On the redaction piece, we had a question. How does that work with redacting part of the evidence? Like using part of the text that's out of context, like just using that part of the text about the trunk. Why take it out of context? Well, I don't know that there was context in that, there was some lead up of describing their relationship or friendship or basis of that. But as far as redaction, we hear make sure to redact, for example, phone numbers. So there's reasons to redact certain information. For example, if there's financial documents, we are very sure to redact bank account numbers and different things that we don't want, other people having.
Yeah, in this case, you're seeing email accounts and email addresses, not only for Johnny Depp and Amber Heard, but, Marilyn Manson, Elton John, I heard at one point. And they're redacting that information because everything that's admitted into evidence now becomes part of the public record. And if you don't want certain identifiable information to be in the record, then you would just redact that stuff out. But you don't redact context. You can always provide context. You're just redacting certain words or identifying information.
Victoria asks, do you guys think the photos of bruises can persuade the jury even though the injuries don't portray what she describes? Yeah, Victoria, so we did discuss that. I think that that's something that, Amber is going to need to overcome as to why we don't have those pictures, right? If you did have a split lip, if you did have something like a broken nose or, blackened eyes, which take a little while to heal. And so there would be an opportunity to take many images over many courses of days and weeks and maybe even months. I don't know what the healing process looks like. But, this goes back to the testimony that we did hear from people who were coming into contact with Amber, right? So we heard from people who were living in the building and saying that during these relevant periods when I was running into her, at the elevator and giving her hugs and giving her kisses, I didn't see any swelling, even to the extent that she was covering up some kind of bruise. And quite frankly, it's really tough to cover up a split lip with makeup.
Yeah, it probably is. We also have to remember the standard here, the burden of proof. In defamation, the burden of proof for a party to prove their claim is just what we call preponderance of the evidence. At least that's what it is in here in Arizona. We have to remember this is all taking place in Virginia. So most of my knowledge, in fact, almost all my knowledge is either federal or Arizona. But all the burdens of proof are essentially the same. And for defamation, it's a preponderance of the evidence. And think of a scale, right? You got the scales of justice. All that means is that it has to tilt 1% in one person's favor, and they have proved their claim. In other words, 51% of 49%. So they don't even have to tell the whole truth. They just have to be telling more truth than the other person, essentially. So to her question, is a bruise enough to prove that there was abuse? It's like, well, maybe she's embellishing her story, but even the bruise is enough to say maybe some abuse did occur. And then, of course, that means her statement was true. And that defeats Johnny Depp's case.
We did hear one of Amber's attorneys object to his own question because he was not liking what the witness was starting to say. So that was a little bit of a oopsie moment for him. And the judge just responded, well, that was your question. So he opened the door and you had to let the witness answer.
Yeah. Yeah, that was oops.
Jen's asking, what does hearsay unmoving mean?
Hearsay unmoving. I've not heard that before.
I don't know about that one. So guys, real quick, if you are just kind of catching this live stream right now, make sure you go and subscribe. If you're watching on Facebook or LinkedIn, make sure you subscribe on Top Music Attorney on YouTube. So we are kind of following the trial. There's other things that we cover, of course, but we're staying close on this. And I've loved having this conversation with you, Tim. Thank you so much for being on this. We're going to do just a couple more questions. I very much respect your time. I know you're a busy guy, so we're just going to hit a couple more. So, we're going to have the continued direct examination of Amber Heard on the 16th. The court's out for this week. The judge had to go to the judges conference and do judgy things. And we're going to be back. And I believe they start, 7 a.m. our time. It's going to be 10 EST. And we're likely going to hear direct examination from Amber for at least another day, if not several more days. And then we'll get into that cross examination. And quite frankly, that's what I've been waiting for. I think that we got some really good information on that cross of Johnny Depp, but we all have a lot of questions. And so we're very curious to see where this goes.
It'll be curious to see where they deviate to. I mean, they now have a week to think about their strategy and what's happening. And so they can talk
I
about.
love that you just said that. I was thinking that. So they have a full week to listen to what Amber has been saying and to get ready for the cross-examination.
Sure. So they can fix things. They can refresh the jury's recollection on that Monday. There's a few things they can do to kind of, well, just make it better. It's not this is unusual, by the way. I mean, judicial conferences do not interrupt in trial. And in fact, I'm curious why the attorneys agreed to this, to set this trial in the midst of knowing it was going to be a week. I would rather have that trial go straight through.
Yeah, that's a very good point. Why is it in Virginia? So my understanding is that the Washington Post, the publication, their main location is in Virginia. And so they decided to do it in Fairfax, Virginia, because that is
it's jurisdiction, right? So it's where the comment occurred and where the damage occurred. So obviously this was in Virginia. I'm sure you could make the argument that because the Post is online, that jurisdiction could really be anywhere or whatever, but nonetheless, Virginia, and they might have a more favorable defamation law.
Yeah, so we talked a little bit about, once we heard the testimony from Johnny Depp and the fact that he lost the tip of his middle finger on his right hand. Now, there's no question that happened, but we are hearing different stories. So Johnny Depp's take of it is that Amber Heard, chucked a vodka bottle at him with such force that it did sever his finger. And then we heard testimony from, he went to the ER. He told them a different story. He said, ouch, I cut my finger off in one instance, or I got stuck in a door. So he had to kind of explain a little bit of why there are these differing statements. But he's saying now Amber Heard was the cause of that injury. And then, we are now going to be hearing from Amber talking about the fact that Johnny Depp actually cut off his own finger, and she did not do that.
Yeah, that's one of the wild ones, right? And that's what I was saying earlier. I mean, nobody's denying these things happen, but the stories and how it led up to is just extremely different. It's not uncommon for somebody to go to an emergency room and lie about what happened when their partner caused the injury. That's actually fairly common. But in this particular instance, that might be, if I'm a juror, right, I'm thinking, well, I mean, do I need it with these other instances? Do I need to make a decision on that? They might, give themselves a pass on it because it's so wildly different.
Yeah, and I think that Johnny did have a good point that he made when kind of explaining how it could not have possibly been him that cut off his own finger, because he is an impassioned musician. This is something that he has done since he was a very young boy. It's one of the only soothing things that he can do. It's cathartic. And so because of all those reasons, why would he do something that prevents him from playing his guitar? And so I thought that was something that I personally could connect with. I could understand that, but I wish that they would have maybe doubled down on explaining what his recovery time was. How long was he unable to play? Was it a few weeks? Was it a few months? Was it years?
Yeah.
And we don't know the answer to that, but I thought that was a pretty good explanation.
Yeah, no, I found that to be pretty credible myself, but it's still a weird story.
Yeah, look, I mean, I'm interested to see if we have anything else that comes out, because we did hear audio, something about, Amber saying, Johnny, don't cut yourself. Who knows at this point. All right, so we do have a question. What does unresponsive mean? We were talking about objections, so Tim, you can hit this.
Yeah, so when you ask a question, a specific question, and then sometimes the witness has a theme in their mind that they want to get across to the jury, so they're not actually answering your question. And so that means unresponsive. So if I ask Krystle a specific question about, on the airplane, how many people were on there, and then she goes in to start telling the story about Johnny was drinking this and Johnny was doing this drug and Johnny was doing all that. That's unresponsive. My question was, is how many people were on the plane? I didn't want to hear your story, right? So it's just essentially not asking the question that's been asked.
Yeah, and that's something that we heard as far as a common objection when Amber Heard was testifying, when she was kind of getting into more flowery language and talking about these emotional experiences and this and that. And then in a very gentle kind of way, Ms. Vasquez would come in and just say, objection, unresponsive. And so it would, again, interrupt that flow and that connection potentially that she was building with the jury.
Right. Yeah. Yeah. And when that gets sustained, I mean, the jury gets left hanging and you're just kind of like, as a juror, you're like, well, I kind of wanted to know that. And so you get frustrated and then you lose your concentration and you may miss something important next. So you as an attorney kind of have to, ramp back up and get the jury's attention again.
Yeah. Yeah. And as far as, Amber Heard's ability to, when there was that interruption, to kind of come out of the emotion and then to go right back into it. I think you made this point at the beginning of our conversation, just saying it's more common that we do see witnesses testifying in kind of a more elongated pattern. They don't come out of emotion so quickly.
Right. Right. Yeah. I'm sorry, I was reading this question as it came across the screen here. I've had experiences like this where people fake cry on the stand. And it doesn't go unnoticed, not just by a jury, but by the judge as well too. So, you really, I've never had a witness personally like that. That was my client do that, but I've had a couple that I've examined where they start to do the alligator tears. And quite frankly, you just kind of let it go because it actually looks good for your case because, that person is generally losing all credibility whatsoever. So.
That's a good point. And I felt that maybe there were certain points even in Johnny Depp's testimony where there should have been an objection. And I felt like from a strategic standpoint, the other side was just letting him talk because he was almost talking himself into a hole. And so sometimes the best thing to do is do nothing.
Yeah. That's unusual at trial. You see that in depositions. You stay silent on purpose so the other person will just start talking. You don't see that in trial too much, but
people don't like that uncomfortable silence. They don't.
And I love social awkwardness. I'll sit there for 10 minutes.
Well, okay, so we've heard a lot of video deposition testimony. And so as far as any objections, any issues, all of that's been dealt with ahead of time. So both sides have agreed to use the portions of the video deposition that we then see and that the jury is seeing.
Yeah,
right.
Absolutely.
All
and
right.
You've seen that edited. That's why it skips around a lot.
Well, and so one of my questions is that depositions have a tendency to not be a little more loosey-goosey, but as far as your ability to raise objections, it's a lot less kind of aggressive and on the ball typically than being in the trial, in the courtroom. So how do you deal with the fact that there are a lot of extra things said in a video deposition? Do you have to go back through the video and just edit out every single time that there was something said that someone else raised an objection to, that the judge then agrees with?
Yeah, well, I'm going to disagree with you a little bit at the risk of getting booted off your show here, but a deposition is two things. Number one, you do pin down the witness in some cases, so it can be very much like trial. But it's also a discovery tool where you're asking information. So all of that stuff where I would be asking for information or just trying to explore an issue or whatever, I'm not going to put that in a video deposition, but I am going to pick the portions that I want. That I've hammered the witness into a corner or I've asked, very specific questions. And I'm going to put that at trial. And I'm sure that these people who did these video depositions, or excuse me, the attorneys, when they did these video depositions, knew that these people would be unavailable at trial. And so they probably changed their process in the deposition a little bit, knowing that this was going to be shown to a jury.
Yeah. Well, and so how do you deal with the fact that often these video deposition testimony that we're hearing is just very, very boring, right? As a viewer, we're watching, we're having a hard time. Isn't it harder for the jury in the actual courtroom to try to pay attention?
Yeah, and you see one of the attorneys standing up saying, now this is going to be questions by this, particular attorney or whatever, try to get the attorney. But, the same could be said for witness testimony, right? You get bored listening to I probably shouldn't say this, but I actually get bored listening to the answers to my own questions sometimes, and I forget where I'm at. So I got to make something up, right? But at any rate, it just happens. I don't think that's a nature of just the video testimony. It's probably, jury's attention, especially when someone's been testifying for weeks on end. It's just incredibly difficult to keep.
Yeah, when we were hearing some of these, a video deposition testimony from, medical providers, the therapists, some of it was a little bit more engaging than other, but you still have to use it, right? There's a reason why they are showing this to the jury, because they need to build kind of foundation, talking about, for example, Johnny's drug abuse, or what were his typical mannerisms when he was on, drugs, or when he was drinking. And so there were kind of these narratives that we were seeing throughout all of the different witness testimony. And I think they did a good job to build that case for Johnny to paint a picture of someone who is not abusive.
Yeah, maybe. I think they did a good job. Don't get me wrong. I think they did what they had to do for sure. I just don't think that this was a case that is going to get them there. I just think there's enough there that the comment in the post is true enough.
So Christine says, what would happen, or she asked, what would happen to her if it was found out that she faked photos of bruises, anything criminal? All right, so how do we confirm the veracity of photo evidence? How do we know that things have not been photoshopped?
Yeah, well, first of all, let's answer the question. Falsifying evidence and perjury are criminal. So, I don't know to what degree she would spend time in jail or anything like that. I mean, I'd have to look all that up. But that definitely is criminal. It's certainly civil contempt. She certainly would see some sanctions from this particular judge for sure, including the dismissal of her claim probably, and probably some fee shifting, meaning she would have to pay a good amount of Johnny Depp's attorney fees if she did something like that. So it could be pretty severe. How do you tell? Just another expert. I mean, it's, you have a client here in Johnny Depp and quite frankly, Ms. Heard, that has enough money that you can do these types of things that you maybe not be able to do with your typical client. So, am I going to hire an expert to look at the digital images? I might in this case. Yeah. Especially these. And, I'm going to ask for those photos in their native format, not a copy of them. And so I'm going to look, if it was taken with a phone, I want to be able to inspect the phone, or I want to be able to at least get that digital download of that so I can look at it. And, there are experts out there that can look at that stuff and decide whether or not it's been photoshopped, it's been screened, or, some sort of filter has been used, when it was taken, where it was taken. So yeah, I would probably be looking at that.
Yeah, and there are legal tools that, allow you to natively get certain files in their raw format, but you're right, you can have expert testimony as well. And as far as just kind of sanctions and what can happen to a party, not just if they lie, right? It's not if they're just lying and submitting falsified evidence, but things like failing to meet deadlines. Right, not complying with court orders. There can be very bad things that happen, from monetary sanctions to having your case thrown out.
Yeah.
So, guys, I'm going to hit one more right now, and then we're going to go into our wrap up. So, Johnny's a jerk. She's terrible, but he's a jerk. Look, Johnny is being caught in some not so great moments. I don't think anyone's going to dispute that. And, this is part of what he has to go through, unfortunately, that they both have to go through in order to get through this case. So, guys, I want to thank Timothy M. Collier for being on this live stream with us. If you want to be part of this community, please be sure to subscribe on Top Music Attorney on YouTube. Make sure to do all the YouTube things, like this video, subscribe. It really helps to push it out so that we can build our family, and it helps the YouTube algorithm gods bless us. So make sure you come and follow on social media. I'm at Top Music Attorney on all social media platforms. I had a great time having Tim on this live stream. It's the first time I've had him on, and this is kind of what we do together every day anyway. We're always talking about cases and procedures, and so I wanted to have him on so we could discuss these things together. So Tim, thank you very much for being here.
Thank you. Enjoyed it.
All right. Well, guys, we are signing off, but we will see you on the next one. Thanks for joining us. I'm Top Music Attorney, Miss Krystle. Bye, guys.